that done is Mr. Bagadol and Mr. Eisenhower are present. The jury is not. Okay.
Judge, may I approach just for a second?
Yes, ma'am.
Let's just put up.
Y'all ready to have him come in?
Yes, sir.
Thank you all very much for your attention and your patience with us, Mr. Bagadol.
Doctor, I think it's going to become painfully obvious to everybody here my math skills are woefully inadequate, so I'm on you, but you told the jury that you've got somewhere north of 80 hours in the case.
Yes, sir.
So just if it were about 81 hours, you'd be talking about a bill of around $29,000.
That's correct.
Okay. Now, you indicated that you have never been retained by or called by the state to testify in a capital proceeding, is that correct?
That's correct.
And I think you indicated when you and I talked in your deposition that you have on numerous occasions addressed criminal defense organizations in your capacity, topics related to your expertise in this area, forensic psychology and so forth, correct?
That's correct.
How many times would you estimate you've conducted such lectures?
Total lectures to attorney and legal groups, sometimes including judges or conferences, are around 100. There are likely about 10 to 15 that were not related to capital-related things. I spoke to a number of juvenile conferences, also spoken to attorneys involved in personal injury-related work. But I would expect that there are easily 80 to 90 capital training conferences that I've spoken at.
Okay. And those are for the vast, overwhelming percentage of those would be for criminal defense organizations, public defender organizations, so forth, correct?
That's correct. I speak to any group that asks me to if I can illuminate the science.
Okay. So now, you've written obviously extensively on the topic, but one of the areas that you address in both in your book that you talked about and maybe some articles that you've written is, you know, an important topic is encouraging mental health experts to be aware of their biases and the need to guard against them to the extent they might affect their objectivity, correct?
Yes, sir, that's correct.
And you specifically warn against the dangers of a mental health professional perceiving him or herself as part of the team, if you will, because that could potentially affect their objectivity, right?
That's correct.
Okay, so help me out here a little bit, because again, statistics, if I was any good at numbers, I would have been a lawyer. But I know this from school, and it's the old adage, there are lies, there are damn lies, and there are statistics. Are you familiar with that?
Mark Twain said that, I believe.
Okay, and what do you think that means?
I don't entirely know. I suppose it's the idea that that by selecting the numbers someone could distort the appearance of things. I suppose it would be not unlike a disingenuous audit or that kind of thing, where cooking the books, that there are ledger books, but those books have been cooked. They don't actually reflect the numbers that have occurred. Part of this, I suppose, from Mark Twain is a little bit of anti-intellectualism. It's kind of throwing rocks at science, which is appealing until we actually need that science to inform something.
Okay, well, let's just, so one of the slides in your presentation, the 25th slide, deals with inmate misconduct in cases that you had been retained to look at, right?
Yes, sir, that's correct.
So and you told the jurors that there were like over 200 cases that you have been retained to testify on kind of this topic, I guess, and I know I'm paraphrasing, I'm stating it very artfully, but 200 plus cases, right?
No, sir. What I described is that I've testified, I think, in approximately 210 to 220 capital sentencing trials. Sometimes I testify about violence risk assessment for prison, like I have today. Where do we go from here? Sometimes I testify or do evaluations of how did this person come to be damaged? What happened to them in childhood that would explain and help illuminate this trajectory? Sometimes I testify about both. Okay. And so the 210 reflects that whole universe of appearances at capital cases.
Okay, so how many total capital cases have you testified on and talked about what you're talking to the jury here about, the statistical probability of future dangerousness? How many total have you been retained on and testified on in those?
I don't have it broken out that way. I have the capital cases that I've identified. I have not separately identified which ones did I only talk about risk assessment or where I did risk assessment plus adverse developmental factors. And so I would just have to guess, but don't know what those totals are.
That's fine. So we'll qualify your answer as a guess, a best guess.
Out of the 210, somewhere between 30 and 50%.
Okay, maybe we do 230.
So 30% would be like 70, and 50% would be 105 or so.
Didn't you testify as it related to that particular slide that you had 74 federal cases, one of the cases you were not able to get the data on because the guy's in witness protection, right?
44 federal cases.
Oh, right, I'm sorry. 44, and one of the cases you couldn't get the data on.
Right.
And then
120 state capital cases.
And you couldn't get the data on how many of them?
75% of those. We only got data on 30 of 120.
Okay, so what total percentage of all of those cases are not reported in that slide? That we don't know what the guy did. You follow what I'm saying?
Oh, yes, sir. The total was 120 plus 44. That's 164. Okay. I could get data out of that on 73. Okay. So I have 73 out of 164. A little bit less than 50%.
A little bit less. So there's a whole other 50% of those cases comport with how they behaved in prison, right? We just don't know because you couldn't get the data, right?
Well, that's correct, and that's why I described that in my testimony, that we had 120 and I could only get it on 30.
I got you. That's fine. And then you also, for the benefit of this jury, you broke out of the group of 111 inmates that had transitioned from death row to life in prison in Texas. You remember that?
Yes, sir, I do.
Okay, and for the jury, what you did in that one is you broke out 6 cop killers.
Yes, sir. Yes, sir.
And you used those numbers to kind of talk to the jury about the statistical probability that a convicted cop killer using those numbers might engage in criminal activity, right?
That's correct.
All right, now, I don't know anything about statistics, but are your results more reliable the bigger group you have to look at?
Absolutely.
Okay, so like for instance, when you got 6, let's say it was only 1 cop killer, okay?
Yes, sir. Yes, sir.
And that 1 cop killer goes to prison and he kills a guard. Would you testify in a court of law that there's a 100% probability that a defendant is going to kill a guard if he's a cop killer?
Oh, no, sir.
No. Okay. And in fact, there are, last year alone, 126 cops killed in the country, and if you multiply that over a number of years, there's a lot of cop killers all throughout the United States, right?
Yes, sir.
And Is there a study, are you working on a study, or are we aware of a study that looks at all of the cop killers in the 50 states in the Union?
I don't have that data.
Okay. Now, what we talked about just a little bit, or what you talked about is, I think a kind of a, well, that what happened is not important, that the facts and circumstances of the case are not as important as his educational background, his age, things of that nature, correct?
I described that there is only a single type of capital offense or context that's been associated with a greater or lesser likelihood of violence in prison, and that characteristic is that the capital offense was committed in the course of a robbery or a burglary. Otherwise, the killing of a child, sexual offense, law enforcement officer, murder for hire, those other characteristics have not been found to be predictive of violence in prison.
So, when you talked and when you interviewed the defendant, did you ask him to express to you his feelings or attitudes about law enforcement?
I did not.
Okay. And in fact, it's your position or your opinion that his feelings or opinions about law enforcement generally, whether they be prison guards or correctional officers or whatever, generally is not helpful to you, correct?
Objection, Your Honor. Any opposed?
Yes.
So again, sir, my question to you was that you indicated that an inmate, the defendant's feelings, opinions about prison guards, law enforcement is not something that generally is of concern for you in this process, correct?
It's not that it's of concern, it's that it's not predictive of violence in prison.
Let me ask you this.
It seems like it would be, like for it to be, but it's simply not.
We're all clear on that. But let me ask you, if you got a guy, let's say he's 60 years old, he's got a PhD, he's had very few bad experiences with law enforcement, he's got a supportive family that's going to visit him when he's in prison, but he tells you over and over, and this is a purely hypothetical, but he tells you over and over, I hate cops, I hate guards, I hate being told what to do, I'm going to act out violently in prison, I'm going to act out violently in prison. That's not something that would be significant to you? I mean, you would put that aside in light of the numbers?
Well, if he announced an intention to imminently hurt a correctional officer, then I would incorporate that into my risk assessment, and I would seek to have that be a part of a written report or to follow him to prison, so that there could be steps that could be taken to control for that. But the features of that he is antagonistic toward law enforcement or antagonistic toward correctional staff is one of those features that's almost universal in a prison population. That these are individuals who have negative attitudes toward the police and largely negative attitudes toward correctional staff. And so that is so pervasive in that context that it's going to fail to predict the rare act of serious violence. That attitude is distinct from, I'm announcing an intention to act.
Okay. Now, why don't you, in your review in this case, one of the things you reviewed were some handwritten notes from the defendant, some Bible verses and things of that nature. You remember that?
I did.
Okay. And in those, there are the following two quotes. And I'm just wondering if these factored into your equation at all, these notes or thoughts of the defendant. It's on the page entitled Quotes, and it's, the first one is, I'd rather die on my feet than live on my knees.
Yes, sir.
And the second one is, a badge in America is a license to kill.
Yes, sir.
And these are writings from the defendant. These ultimately do not affect your overall opinion with regard to the analysis you conducted, correct?
That's correct.
All right. So just kind of to summarize, I just want to make sure that I'm clear on this. When you talk to them about context, the big context here is that where he will be, whether he's sentenced to death or life, is in an institution in which they will control his movements very, very strictly, correct?
That's correct.
And so it is in that context, and not the context of him out on the road, driving around in a car with a suspended license and a firearm as a convicted felon, that you render an opinion that he's not likely to kill or do serious, or it's extremely or severely or greatly unlikely that he's going to kill or do serious bodily injury in prison. That's your testimony.
This is specific to a prison context.
Okay. Thank you.
Defense have any redirect?
No, Your Honor.
Thank you, Doctor, very much.
Thank you, sir. Thank you.
Get all your things and watch your step there.
Yes, sir.
Defense, call our next witness, please.